brings us now to module 2, right? Of the 2021 paper. So here we're asked to define the following term, the doctrine of separation of powers. Somebody go ahead. I know you guys have this in the bag. Separation of powers. Let's go.
So it's basically the areas of the government, the executive, legislation. They should not well, not influence. They have to influence themselves, but their roles should not clash with the judiciary, which is an independent body.
Okay. Alright. Anyone else? Go ahead.
The doctrine of separation of powers refers to that there may be a clear demarcation between each branch of government, and that each and the powers should be held in check by the other branches.
Okay, we're looking at the separation of power to prevent absolutism, right? And the checks and balance systems, those type of things, as stated by John Locke, as stated by Montesquieu, right? Okay, the rule of law, define it. Go ahead.
According to Professor Fiajo, the rule of law says that every man should be treated the same way under the law, no matter their status in
Okay,
society.
that's one thing that Piaggio said. Okay, rule of law. Anyone else can add to that?
No, wait, was it Dicey?
No, yeah, Piaggio and rule of and Piaggio and Dicey, that spoke about it.
Oh, okay.
Okay. There are three main proponents. Well, four main proponents, I guess. Aristotle, Dicey, Piaggio, and the Declaration of Delhi that we spoke about, right? Well, let's go rule of law. What is it? Let me look at the chat because I haven't been looking at the chat. Let me look just in case anybody. Oh, so people gave definitions for the doctrine of separation of powers. Okay, so I see it. Okay, so generally the same thing. So we look at the fact that no man is above the law, right? Everybody is subjective to a fear. We look at the things that we talk about, right? No man is above the law, right? Everybody is perceived innocent until proven guilty. The law must be transparent and predictable. We're looking at natural justice. We're looking at equity. We're looking at all of these different things. We must justify the rule of law. The rule of law states that the law is above every single citizen, and all citizens must be viewed equally under the law, and all citizens are supposed to be and the law prescribes different fundamental rights and freedoms that must be adhered by any government, seeing itself that the rule of law is above all. We're talking about these different types of things that relates to the rule of law. Alright? So all of them something here we're talking about. Outline three functions of the executive arm of government which practices the separation of powers.
Sir, they create the laws,
The executive,
which, yeah.
the legislative create the laws.
Oh, sir, doesn't it go executive, legislation, then judiciary?
No, no, no. Wait, hold on. The
Am I mixing
legislative
it up?
create not yeah, I think you mix it up. Right? Legislative
Oh,
create the laws.
legislation, executive, then judiciary.
Yeah.
My bad.
No, that's fine. That's fine. People make mistakes.
Oh, so the executive enforce. Everyone said it already. They enforce the laws, not make them.
Enforce the laws.
Enforce the laws created by the legislature.
Laws create the voila. What is happening? Alright? So we said that enforce the laws. So the what the judiciary do? Sit and look pretty. Interesting. I think there's a reason why them ask this question now, because everybody knows what legislative and judiciary do, but people are foggy as it relates to what the executive do, right? They do aid in the implementation, right, and the enforcement of some laws, right? They do, right? But that kind of overlaps a little bit because the Westminster system kind of concept you guys are using now, right? It overlaps a little bit with the judiciary, right? The executive branch is responsible for the implementation and enforcement of the laws passed by the legislature, right? Via the judiciary. So the via or through could be important. Go ahead, Odette. Your hand is up, but I don't hear you saying anything.
Are you hearing me now?
Go ahead.
Right, I was just saying that the executive is the arm that actually make the different policies. So if it is that the government of a country wants to implement certain policies, it is the executive arm that does that. So whatever plans, if it is that they want to reduce crime, whatever it is that they want to do as a policy, they are the ones who make that. But the parliamentary, the legislative arm would be the ones who make the laws now to support or to enforce those policies that they would come up with. And then the legislature would be the arm that enforce those laws.
All right, lovely. Thank you for that. Beautiful, right? So the executive, for this question, right, we're asking for the executive arm. We're looking at the creation of policies, right? So it's usually policy creation that we look at, right? So some persons tend to say that okay, the laws go to the executive to be overviewed and those other things, but the legislature make the laws specifically, right? The executive can read through and can look at these different laws, right? And look at the wider society in order to figure out how we create policies that will better govern the society, right? They also have an administrative process, not process, but function, right? As it relates to regulating and overseeing, right, government agencies and public services such as health, education, transport. You know, the ministries, the different ministries, the executive look over that, the different ministries, right? So we're looking at those type of things, you know. The judiciary over will look at any infringements that those ministries will make, right? But overall, the executive will manage the ministries, right? We're looking at those type of things, right? They have a distinct administrative role, separate from the legislature and separate from the judiciary, right? And their role in making policies, right, is separate from the legislation and also separate from the judiciary, right? So the Parliament would make the laws, right? Legislature would make the laws, right? The executive would look at policies, right? Specifically, and judiciary would interpret and enforce the laws made by Parliament, right? The administrative function now, as we stated, the executive would actually look at the operation of different ministries and public services and service commissions and those type of things that we learn in Module 1, right? Specifically, while the judiciary now will function as resolving disputes when those ministries or those functions now intervene in different types of legal proceedings or interrupt the constitution, and we know that happens with the judiciary through judicial review. There's also the conduction of like things like foreign affairs. They generally deal with foreign policy and stuff like that, international relations, and basically they would be the type of persons that will now look at agreeing to different implementations as it relates to matters of international law, right? And then the judiciary will now interpret and enforce those laws if the country were to accept those articles of international law. There are a lot of things that the executive does, right? But it's usually in policy management and usually in the administration of public services and management of ministries, right? Usually those things we look at for the executive arm. Alright? So we're supposed to talk about those things and how it enhances the practices of the separation of powers. And usually they want you to look at those functions and look at the fact that other arms do not do those functions, and they probably want you to input probably one or two functions that allows the check and balance, the checks and balances system, right, on the judiciary, or well, not the judiciary. Judiciary is completely independent, right, but on the legislative, right, and how that works, right. So we're looking at those type of things. So it's a huge discussion question, 6 marks generally. Here now, the Attorney General of the Independent State of Imo drafted legislation called the State Justice Act, which was passed in Parliament. The Act now gives the government the power to determine from time to time the criteria for hiring members of the judiciary. In addition, the Act also gives the Attorney General the power to review or change sentences. The Attorney General? That's crazy. Right, sentences handed down by competent courts. If the public or the government disagrees with the court sentence. So if the public or the government disagrees with the court sentence, as head of the law association or legal association, discuss what legal actions could be taken against the Attorney General. Because what on earth is the Attorney General doing in this case? What are the issues, guys? What are the main issues? No one's supposed to be hearing raises of hands and people ready to go in. Somebody just stated ultra vires. He's doing the judiciary's function. Alright. So let's do it in order, because I adore order. Order is something that I do love. Right? So the act now gives the government the power to determine the time, from time to time, the criteria from hiring judges. Now this endangers the independence of the judiciary, and this would lead to more corruption within society. Remember, the independence of the judiciary is important now. The question is now asking the student now. It's not they're not explicitly asking you, but they're saying, okay, if we drop this in the scenario, does this candidate know the importance of the judiciary being independent? Can this candidate now identify what occurs when the government, right, when different parts of the government now have power to hire members of the judiciary? Speak about corruption, speak about political affiliations, right? Now the government will actually choose judges that will actually be on their political party or their side of the political spectrum for the judges to pass sentences, right, that are in favor with their political values. Look at the corruption, look at political influence, look at the endangerment of the justice system when the judiciary is not independent. The act also gives the Attorney General the power to review or change sentences handed down. Who could I tell the Attorney General that he has the right to judicial review? This is called judicial review for one purpose, right? And to change cases handed down. How can he overrule cases? He's not a member of the Supreme Court. He's not the Supreme Court. Look at how we're infringing on the rights of the judiciary there. As we said, they're acting ultra vires and in conflict with the Constitution. In both cases, he's acting in conflict with the Constitution, because the Constitution states the independence of the judiciary and the functions and roles of members of state. The Attorney General, even though he handles matters that are civil on the behalf of the government, he has no right to do any of this. It's ultra vires, unconstitutional. Therefore, the law or the legislation that is drafted by the state is unconstitutional. The State Justice Act is unconstitutional and null and void. Speak about these things. You can use examples, right, from your own constitutions as well. Now, the two decided cases that we're looking at now, which two decided cases would help here? Two decided cases. Hines v. R., where the Gun Court Act of Jamaica had the audacity to give the Governor General the right to sentence persons in a court, in a high court. The audacity. The doctrine of separation of powers directly would inhibit this. It is not the right of the executive, but the judiciary to sentence. And we also have Colin Moore when we're looking at conflicts and substantive as well as procedural ultravirus. You guys can speak about these things. These cases are important. Everybody must know. Every Jackman and Jill must understand, right? These two cases, Hines v. Aaron Collymore v. Attorney v. AG. Even when you go to university, right? When you go to law school, the same cases are gonna be used. So if you're going to be pursuing law, it makes sense to learn it now and learn it properly. Alright? That is the end of the paper. And we did module 3 already. Alright? And I guess this is where we say goodbye. That's the end of my assistance with your preparation for the exam.